NACDL is the association of the nation's criminal defense bar.
So I'm going to talk to you about this one particular surprising surveillance program that until 2 months ago was totally secret to anybody outside of law enforcement. It's sprawling. It has not yet been challenged. This is new. And you all are going to be at the front lines with your colleagues potentially finding a case where this data is implicated and bringing the first wave of challenges to try to get some redress for your clients and maybe make some new Fourth Amendment law. There's a practice advisory, NACDL practice advisory on this topic that's newly up on the online portal where you downloaded your materials. So I encourage you to download it. Big thanks to Max Berman, who's in this room, for drafting it. OK, so what are we talking about here? 2 months ago, Senator Ron Wyden revealed the results of an investigation by his staff that revealed this really sweeping, long-standing surveillance program operated by a constellation of government actors totally in the background that was collecting huge quantities of records about Americans' money transfers, wire transfers, dumping them into a big database, making them available without any legal process whatsoever to thousands of law enforcement agents across the country. So this story involves shady dealings by the Department of Homeland Security, by the Arizona AG, by Western Union, by this weird nonprofit that the Arizona AG set up, and by a whole bunch of other wire transfer companies. So I'm going to describe to you what we know about this, and then talk about some of the Fourth Amendment theories that you might use if you can discover that this was actually at issue in one of your cases. OK, so let me give you the history of how we got to today, and let me I'll describe in particular what we're actually dealing with. So this started with the Arizona Attorney General's office in about 2006, who decided that they thought that Western Union was not adequately scrutinizing certain money transfers to a particular state in Mexico that the Arizona AG thought were paying for human smuggling. So they issued an administrative subpoena to Western Union seeking effectively all records of all money transfers to or from this Mexican state of Sonora over a wide time frame. Western Union resisted this subpoena on the basis of overbreadth, challenged it in court. The Arizona Court of Appeals struck it down on statutory grounds, saying this fails the relevance test under the enabling statute that you issued the subpoena under, and also raised serious Fourth Amendment concerns. Not chastened, the Arizona AG kept going, ended up suing Western Union under a state anti-money laundering law. And they, in 2010, reached a settlement where it included a whole bunch of kind of administrative compliance measures about Western Union adequately checking transactions that were going through it. But the big thing that happened for our purposes is that Western Union totally rolled over on its customers and agreed to send bulk records to the Arizona AG. These records covered the following. So it was every wire transfer or money transfer of Western Union's for more than $500 that originated from or ended in any of the southwest border states or Mexico, right? So Texas, California, Arizona, New Mexico. So that means every wire transfer of $500 or more between a California resident and their grandma in Oregon. Every remittance from an immigrant living in Texas to their family back home in Ecuador. Every transfer from New York to a friend in Mexico City. Every Western Union wire transfer from somebody living in one corner of New Mexico to their friend in the other corner who had emergency surgery and needed money, right? Really wide sweeping set of records. All these just being dumped in bulk by Western Union to the Arizona AG pursuant to the settlement. That kind of went on in the background in quiet for 4 years during the term of that settlement. The settlement was about to expire. The Arizona AG wasn't happy with that, so they renegotiated a second settlement agreement to continue that bulk dumping of customer data. But with this added twist, the second settlement agreement in 2014 created this nonprofit entity called the Transaction Record Analysis Center that would receive, going forward, all of these Western Union data, package it, and make it searchable to other law enforcement officers around the country. That went on for another 5 years, just dumping data into now this nonprofit entity that was essentially run by the Arizona AG. Then the settlement agreement was expiring again, 2019. There was no theory anymore under which the Arizona AG could argue that Western Union was no longer in compliance with the law, so they couldn't keep them under a settlement. So instead, they worked out this really odd arrangement that involved the Phoenix Field Office of Homeland Security Investigations. As many of you know, that is the criminal investigative arm of Immigration and Customs Enforcement under DHS, whereby this HSI Phoenix Field Office every 6 months would issue an administrative subpoena, a summons, under a customs inspection statute to Western Union, asking for the exact same bulk data for the next 6 months, a prospective request. And then Western Union, on an ongoing basis over that 6-month period, would report these transactions, exactly the same as what they'd been reporting under the settlement, dump them into this private database. So you have federal agency directing with a dubious summons, which I will explain the illegality of soon, directing a private company to dump these huge bulk records not into federal government hands, but into this nonprofit entity that was set up by the Arizona AG. Really unusual. 2019 to 2022, to this year, every 6 months, a new summons was issued, and Western Union kept reporting. In 2021, a second company called Maxi Transfers, it's another money transfer, wire transfer company, started getting these subpoenas as well, all going into track. Now, meanwhile, since 2014-ish, a steady stream of other wire transfer companies started, quote unquote, voluntarily dumping the exact same records into this track database. So you now have Western Union and this other company, Maxi Transfers, under these weird subpoenas, which I'll talk about. And then you have at least 24 other wire transfer companies deciding, you know what, forget the legal process. We're just going to give you this out of the goodness of our hearts. We don't know what happened behind the scenes, and I'll talk about how you might use discovery to figure out if this truly was a voluntary set of disclosures. But what we ended up with is a huge quantity of records. So over that whole period Western Union was dumping records in, it totaled about 6 million records of customer transactions from those border states in Mexico. But that's only 3% of the database that's sitting in this weird nonprofit track, right? So in total, about 200 million records, most of them from these companies that are doing this quote unquote voluntary reporting, are sitting in this database. And what happens to them? Well, Track signs up thousands of law enforcement agencies from hundreds of state, federal, and local law enforcement agencies around the country with direct login access. No need for legal process, no need for a warrant, not a subpoena. You just have a login and you go run your queries. This graphic on the side, this was a program that was kept pretty under wraps, except the Arizona AG and Track contracted with Raytheon, this big government contractor, to build the platform. And Raytheon, of course, put a glossy PDF up on its website trumpeting how cool this thing was. So you have all this kind of description of all the various search queries that can be run, pretty sophisticated and effective. So this has been running for years. There are untold numbers of people who have been charged with crimes based on evidence in part coming out of this database. But I'm only aware right now of one that we can point to that was mentioned in a Wall Street Journal article following Senator Wyden's disclosure of this program. Surely there are hundreds, probably thousands more criminal defendants who came to the attention of law enforcement in significant part, maybe only because of queries to this system. So you figure out that maybe your client came to the attention of law enforcement in part because of wire transfers through Western Union or another company. What do? Well, let me tick through some possible legal arguments, mostly Fourth Amendment arguments that you might make. So first, important to note that these summonses were clearly illegal as a statutory matter, right? So DHS was using a custom summons statute that allows for narrow kinds of requests for records in investigations around the importation of merchandise or the payment or non-payment of customs duties. There's no question that the statute is not properly applied to a bulk request for money transfer data, including money transfer data that was entirely within the US, right? Not even international in character. Unfortunately, there's no suppression remedy written into this statute. Now, there are arguments you can make for a kind of implied suppression remedy under federal law. They're hard. They probably won't work, but it's worth making and worth pointing out atmospherically that this is clearly illegal as a statutory matter. Then, of course, we got to think about the Fourth Amendment. So here are a few arguments you might think about making. So first, without even talking about whether a warrant should have been required, just look at whether these were proper subpoenas, right? They're called summonses under the statute. It's the same as an administrative subpoena, right? The Fourth Amendment regulates subpoenas. It's a pretty low bar, right? It's a relevance standard, basically. Relevance, lack of extreme overbreadth, can't be too burdensome. There's no world in which these satisfy the relevance requirement, right? Whatever investigation these subpoenas were purported to be related to, who knows? But their perspective for everybody's records all the time, right? Clearly, probably all the records, at least the vast majority of the records, had no relevance to any present investigation because they didn't even know it was coming in, their prospective and their bulk. Now, the problem for you as a defense attorney, of course, is like, can you complain under the Fourth Amendment on behalf of your client about a subpoena issued to a third party, right? Traditionally, the Fourth Amendment, quote unquote, standing requirement would have it that your client has to have either a reasonable expectation of privacy or a property interest in the records in order to be able to assert their Fourth Amendment rights. And we'll get to that in 1 second. But I think it's worth arguing that these were so per se illegal and unconstitutional at the outset, and they clearly implicate your client's records, that they should be able to challenge them and to seek suppression based on their gathering with these unconstitutional subpoenas. But that then brings us to the normal arguments we make under the Fourth Amendment, right? To try to argue either or both that there's a reasonable expectation of privacy in these records or a property interest is implicated. Now, under the reasonable expectation of privacy test, the problem obviously is the third-party doctrine, right? Supreme Court in 1976 in the Miller case said that bank records that you share with your bank, account statements, canceled checks, et cetera, are not protected by the Fourth Amendment. You've assumed the risk that the bank might give them to law enforcement, too bad for you. That's still, quote unquote, good law, even after Carpenter in the Supreme Court, right? Carpenter says, third-party doctrine means something different in the digital age. We have to look at each case differently, but it didn't overturn Miller or Smith, the other big third-party doctrine case from the 70s. So what can you argue? Well, you should try to argue that, sure, bank records, including maybe wire transfer records, are covered by the third-party doctrine in a normal investigation. But when we start talking about this level of bulk dragnet collection, a different rule should apply because in total, it paints an incredibly detailed picture not only of your client's life, but of the lives of millions and millions of people, all aggregated here. And there are certainly some case law suggesting that different Fourth Amendment principles should apply in that kind of a context. Then there's a property-based approach. Right, so we're used to thinking about the kind of trespassory test that Jones, the GPS tracking case, gave us again in the Supreme Court, right, that physical trespass on an object to gather information is a search. Well, if you haven't read Justice Gorsuch's dissent in Carpenter recently, I would urge you to, because he charts out a theory of how you might use this property-based approach to get around the third-party doctrine, to find a source of what he calls positive law, either tort law or property law or statutes, most important in this case, that give people some set of rights in data held by a company. So in Carpenter, about cell phone location data, Justice Gorsuch pointed to the Federal Telecommunications Act, which prohibits cell phone companies from selling your location data that they hold without getting your consent. And he said, that gives you essentially some of the sticks in the bundle of property rights, right? You can control a little bit how it's alienated. Maybe that's enough to give you a property right that gives you Fourth Amendment rights. Here, there are federal statutes and state statutes that similarly prevent financial institutions from giving away your financial information, including this kind of transactional data, without your consent. Maybe that's enough for a Fourth Amendment argument. Okay, now just final thought on Fourth Amendment very quickly. I see my time is almost up, is that what I'm talking about so far is like 3% of this huge database, right? This is the records obtained via these clearly illegal, probably unconstitutional subpoenas. What do you do with the other 97% from these companies that, quote unquote, voluntarily dumped it in? Well, the first thing you do is really aggressively try to discover information through the pretrial discovery process to figure out how voluntary really was this, right? Was the Arizona AG leaning on these companies, threatening charges? Was this really state action? Is this actually a search and not sort of a voluntary disclosure, private search doctrine kind of situation? We don't know yet. We have FOIA requests pending. We don't have more records. You might actually, if you find one of these cases, have a better ability to pry some records out from the prosecutor's office in your case, but also thinking about third-party subpoenas to the Arizona AG or this weird nonprofit track. And so I'll just close by saying, the wider the discovery you can get, the better, obviously. You're used to that. But also, because so little is known about this by the whole defense community and privacy civil liberties community, there's really an extreme public interest in the first defenders to find these cases really pushing to get more information so all of us can benefit and bring challenges. I will end there. I will just say in closing that I work on a wide range of issues around Fourth Amendment in the digital age at the ACLU. I'm part of a project there, the Speech Privacy and Technology Project, that works on this stuff. If you have cases posing these kinds of cutting edge Fourth Amendment or similar issues, you think maybe an amicus brief would be helpful or our involvement might be useful, we would love to hear from you. Please feel free to reach out. Thanks very much.